Good morning. My name's Oliver McEntee and I'm a member of the commercial insolvency teams in Chambers. I'm just told you had me on mute and won't, of course, a word of anything I just said now. I expect I'll be somewhat briefer than my colleague Nick. This is confined to a relatively narrow issue, that of the recent so-called temporary Insolvency Practice Direction, which came into force on the 1st of October this year. The background to this is that right at the start of the pandemic, indeed 6th of April of last year, various changes were implemented via a temporary Insolvency Practice Direction designed to facilitate remote working in the courts and the remote filing of documents. Curiously, although it's titled a temporary Insolvency Practice Direction, certain of the changes introduced by the temporary Insolvency Practice Direction were made permanent as from the 1st of October 21. The preamble to that document states that the changes were not temporary ones connected with the pandemic, but were permanent ones in relation to the way that insolvency business is to be conducted. And it appears from the face of the operative part of the document that this temporary Insolvency Practice Direction will be with us unless and until it's repealed or amended by a substitute one. Most of you on the call this morning will be familiar with the Insolvency Practice Direction. For the more junior people on the call, it's something of a curious document in that it's a hybrid of, on the one hand, of guidance and reminders regarding certain provisions of the insolvency rules and the Insolvency Act, but it also contains some supplementary rules which can catch the unwary litigant out. It contains, for example, provisions in paragraph 9 dealing with the pre-issue search that has to be carried out before a bankruptcy petition is launched, rules regarding the payment of fees and deposits, rules regarding the content of the petition, which are supplementary to those set out in Rule 7.5 of the Insolvency Rules. And then there is, of course, counsel's favourite, which is the dealing with the manner in which errors in petitions are to be dealt with on the hearing of a petition. There are also provisions within that regarding statutory demands and the procedure to be followed in relation to set-asides. One particular point upon obstacle one might trip if one is not aware of it is the filing rules in paragraph 11.4. 3, a statutory demand application can be dismissed if you fail to supply the requisite number of copies. It may look like a small point, but it's one of those of which one ought to be aware. There are also usual provisions regarding the steps which will normally justify an order for substituted service. There are provisions regarding the conduct of applications for validation orders. There is a summary of the various routes of appeal. And then, of course, you have the provisions regarding remuneration of office holders. And in that, you have a useful overview of, firstly, the principles to be applied when an office holder makes an application for remuneration, and equally some specific particulars that must be covered in evidence and various backup documents. That's certainly a useful provision to be aware of. And then there are some miscellaneous provisions regarding unfair prejudice applications and just an equitable winding up applications. In terms of the changes made by the temporary Insolvency Practice Direction that came into effect last year, those fell into 4 categories. There were provisions made in relation to the filing of out of documents to do with the appointment of administrators out of court hours electronically. There were provisions for remote hearings. There was a provisions for statutory declarations to be given remotely, and equally there are provisions to do with the e-filing of documents for obtaining a moratorium. In terms of what has been retained in the Miscellaneous Insolvency Practice Direction, it is essentially everything other than the remote hearings provisions of the temporary practice direction that preceded it. And I'll come back to the issue of remote hearings in a minute. In terms of the three areas which have been made permanent, the Miscellaneous Insolvency Practice Direction lays down rules regarding the time at which the following notices are deemed to be sent. And effectively, if you file these notices through the court system, then the time that you get on the receipt stamp from the court will be the deemed time upon which the notices are sent. Those are a notice of intention to appoint an administrator under paragraph 27 of Schedule B1, a notice of appointment filed by a qualifying floating charge holder, and that's paragraph 18. And then you have a notice of appointment by a company or its directors of an administrator. The one point to note in terms of out-of-hours submissions is that while the first and third of those categories of documents can be filed outside of court hours, those being 10 in the morning to 4 p.m. A notice of intention to appoint filed by a floating charge holder cannot, under the terms of the new Insolvency Practice Direction, be filed outside of court hours electronically. And to be clear, it's not simply a matter of the document being deemed to have been received the next day. That's what happens with the first and third categories of documents. It simply isn't deemed to be filed. So that's something to be particularly careful of if you're going to file the notice. And as you'll see below, if it's served out of court hours electronically, the document is deemed to have been received at 10 a.m. on the next day upon which the court is open. The second change which has been made permanent, perhaps unusually, is the provisions relating to statutory declarations. By statute, the statutory declarations for which Schedule B1 makes provision must be administered in the presence of the solicitor or barrister who's taking the oath. And what the courts implemented in the temporary Insolvency Practice Direction was a workaround, because clearly the courts couldn't simply undo or ignore the effect of the statute. But the temporary provision said, well, yes, there's a requirement for a statutory declaration, but the general power under Insolvency Rule 12.6 can be used to relieve against the non-compliance where there is no substantial injustice. And what has been laid down in the temporary Insolvency Practice Direction is that where the oath is effectively taken by video conference, that will be deemed to be, it's not strictly deemed to be an effective statutory declaration because it can't be. The courts will not regard that as a defect causing substantial injustice. So I suppose by the slightly curious vehicle of procedural rules, the statute has in effect been disapplied. And it's interesting that that isn't simply confined to the pandemic. That is a change which on the face of it has been made permanent, or at least until further notice. The final change again relates to the filing of documents seeking a moratorium. And as with the notices we saw before, those are deemed to be filed at the date and time in the email receipt sent. Those are all relatively humdrum changes Although, of course, they will be of use to administrators seeking an urgent appointment. What hasn't been retained, as I indicated at the outset, is any of the provisions for remote hearings. Under the temporary Insolvency Practice Direction, the practice was that by default, all winding up and bankruptcy hearings were to be held remotely. And there was a separate regime of provisions dealing with other kinds of insolvency hearing, which called upon the parties to consider whether or not a hearing should be remote or in person, or a hybrid of the two. It's not clear what to read into the significance of the non-retention of those provisions. I'm sure I'm not alone as a court user in finding that the use of remote hearings, particularly for uncontested bankruptcy and winding up matters, has been something of a boon. But bearing in mind that many of these matters will last seldom more than 5 to 10 minutes, the actual parties affected often don't attend. The consideration that public justice needs to be done in public, in my personal view, is not one that weighs particularly heavily. And it would have been, if these provisions had been retained, it seems to me it would have been in the interest of court users as a whole. I suspect part of the rationale for the non-retention of this is that whereas the changes, the first 3 changes we looked at before, were effectively mechanical, I suspect there's a perception that to make changes in relation to remote hearings permanent would be a more radical step, and one that it's probably not appropriate to do through the vehicle of a practice direction. Nonetheless, were those changes to be made permanent or revived in some form, at least in respect of uncontested matters, it seems to me that such a change would be a welcome one. But that may be very much a whole talk in itself. Well, as I indicated at the outset, the practice direction is coming to relatively self-contained, and I intended to be brief. If anyone's got any questions on that, please do let me know.